It is an absolute pleasure that I have the opportunity to introduce our fabulous speakers. I will start with what is Safer SF without Boudin. It is a Democratic-led, diverse coalition of community leaders, small business owners, activists, and parents joining together to help make San Francisco safer. The campaign is pursuing the recall of the current San Francisco District Attorney, Chesa Boudin, in order to ensure that SF has a DA who will promote and uphold public safety and build a safer future for the San Francisco residents. Brooke Jenkins and Don Dubain are two of 61 assistant district attorneys who left the San Francisco District Attorney's office since DA Chesa Boudin assumed office. They joined the Safer SF Without Boudin campaign as volunteer spokespeople last October. Let me tell you a little bit about Brooke. She has an amazing resume. Brooke is an attorney who was most recently employed as an assistant DA to the San Francisco DA's office. At the time of her resignation in October of 21, Brooke was assigned to the Homicide Unit. Prior positions included being part of the Child and Sexual Assault Unit and previously served as the Hate Crimes Prosecutor. She has completed over 25 criminal trials, and she has served in the DA's office for over 7 years. Prior to serving in the San Francisco DA's office, she represented automotive companies in high exposure product liability and personal injuries across the country. She began her career in Atlanta, and she represented foreign and domestic companies in high exposure product liability cases. She received her undergraduate degree from UC Berkeley in 2003, and she thereafter obtained her law degree from the University of Chicago Law School in 2006. Brooke is married, the mother of 3 children, and currently resides in the Mission Bay area of San Francisco. Now let me tell you a little bit about Don Dubain. Don has served as a prosecutor for over 30 years prior to managing, or rather resigning from his position in the San Francisco DA's office in October of 2021. At the same time, Brooke resigned in order to join the campaign to recall the DA Chesa Boudin. Before joining the San Francisco DA's office, he spent 20 years in Solano County DA office, where he prosecuted a wide variety of criminal cases until 2010, when he was elected as the Solano County's district attorney in 2014. He joined the SF's DA's office, where he returned to the courtroom, and he has prosecuted over 130 jury trials throughout his career. Prior to becoming a prosecutor, he was also a legislative assistant to Congressman Pete Mcallister in Washington, D.C., and served as a financial manager at a venture capital firm. He received his undergrad degree from Stanford in 77, an MBA at Yale in 84, and his law degree at the University of California, Hastings in 91. He grew up in the Bay Area and is currently living in the financial district and serves as a devoted stepdad and dog owner. As you can see, we have two amazing people and resources here, and let's give a warm Golden Gate Breakfast Club welcome to Brooke and Don. Okay, so please, Brooke, Don, whoever would like to go first, and welcome. Thank you. Take it away.
Thank you, Betty, and thank you to everyone for having us this morning. We do truly appreciate being able to speak with you. As you just heard, I spent the last 7 years up until October in the San Francisco District Attorney's office. It was a life-changing development in my career when I joined the office. I have felt nothing but passion every day that I set foot in that office to both be the last sort of voice for victims in the criminal justice system after they experience sometimes the most traumatic thing in their lives, but also to feel, a sense of protection for San Francisco and its residents. I, as you just heard, was in the Homicide Unit at the time that I left the DA's office. I actually was promoted to that unit shortly after Chesa was elected by Chesa himself. And my decision to leave the office was a very, very tough one. As I, just shared, this was a career that I truly loved. And at the time that the election took place in 2019, I was optimistic that whoever won that election would have the best interests of this city and the best interests of the office at heart. And I actually, what most people don't know is that I actually was contacted by Chesa while he was campaigning for the office. And he asked to meet with me about the campaign and about the office and what any advice that I could give him, as we had known each other, given he was a public defender here in San Francisco. And I did take the time then to meet with him, which was something that was somewhat taboo for those in our office. They felt that, the other candidates would be much preferred to him. But for me, I just wanted whoever took over to succeed. And so I wanted to make sure that he had information from those of us that had been in the office and were experienced attorneys about what, needed to change within the office and any advice I could give. And so I met with him for about an hour at a coffee shop on 7th Street near the courthouse and told him my thoughts. He shared with me that he wanted to build trust with the attorneys and asked me how I believed he could do that. And I shared with him that one of the concerns was whether or not he would come in and fire a bunch of people. He indicated at that time, let your colleagues know that that is not my plan. And so the first red flag for me actually went up when his first day in office, he fired 7 of our most experienced prosecutors, 4 of whom were managers, 1 of whom was a 30-year veteran in the office and our only African-American manager. And for me, that sent a signal that not only had he been disingenuous during our conversation at that coffee shop, but that our office was losing a vast amount of experience that day. Those who had institutional knowledge, some of our best and most experienced trial attorneys, those that I had went to as I had stepped into the office to seek advice about how to handle cases, how to, trial advice, and how to grow in my career. And so that was sort of the first red flag. The next sort of big thing was that my husband's cousin was murdered in the Bayview district, July of 2020. And I saw as the office made political policy decisions that impacted whether or not that case was charged. It actually wasn't in the beginning because Chesa made a decision that gangs are not something that he is going to believe exist in this city or in any other city. And so he wouldn't use gang charges, which were necessary to prosecute those killers. And they remained out on the street, 2 of them shooting other people during the interim time before they were rearrested 11 months later. The final straw for me was I was in the middle of a jury trial on a very, very heinous and brutal murder case. And I had secured a conviction from the jury in that case, but Chesa decided to intervene at the second phase of that trial, which was the defendant had pled that he was insane at the time. And so we were at the phase of the trial where the defense had to prove that he was insane. And Chesa instructed me to agree that the defendant was insane. That was without any conversation with me about the facts of the case, about the expert reports. He didn't request to read the case file. He didn't request to read the reports from the 4 experts who had interviewed and assessed the defendant. He simply made the decision based on an email from the public defender who was a former colleague of his and actually a former office mate of his at the public defender's office. And what most people don't know is that it's not just about whether the person goes to prison or a mental hospital when they are deemed insane. When you are found to be insane, you are eligible to petition for your release within 1 year of your conviction. And so this was a person who was going to be eligible to return back into our community, actually just in a few short months from now. And I believe that the way that he went about making that decision was completely irresponsible and reckless. He didn't consult with the family members that were supporting the prosecution. And like I said, he didn't even take the time to get a full understanding of the evidence within the case and the thoughts and perceptions of myself, who had been in the courtroom trying that case for 7 weeks, questioning every single witness that took the stand. And so that was not the type of leadership that I believed I could continue to work under, given I had spent the last 7 years devoted to protecting San Francisco. And so that is why I ended up resigning in October. And I'll turn it over to Don now to share his experiences.
Thank you. Thank you, Brooke, and good morning, everybody. Thank you for having us. My name is Don Bain, and like Brooke, I chose to resign last October on the same date as Brooke did to join this campaign to recall Chesa. I also shared Brooke's disappointment on that first day when Chesa took over and fired 7 of our most experienced, competent prosecutors in the office. I had a good relationship with Chesa. I knew him from trying cases in the courthouse as an opponent. He was with the public defender's office, and I personally liked him. I also had met with him, shared my advice on how I thought he could be a good DA. I frankly thought that any district attorney elected in San Francisco was likely to be a progressive district attorney in the same tradition as Kamala Harris and George Gascon before him or her. And so I frankly was optimistic that Chesa could grow into being an effective leader for our office. And since I liked him personally, I thought he actually might be a good manager. So I was deeply disappointed on that first day when he fired these 7 experienced prosecutors like Brooke. But I moved on, much to my disappointment, and I continued the work of the office, which for me was focused on serious domestic violence cases. I think the first or the second really event that happened that caused me to lose confidence in Chesa's management was the case of Troy Mcallister. For those of you who don't know of this case, Troy Mcallister was an 8-time convicted felon who was in custody and had been sitting in custody for 5 years under the previous district attorney, George Gascon, pending trial on a robbery case. And because of his extensive criminal history, including 2 prior robbery convictions and an attempted carjacking conviction, as well as 5 other felony convictions, he was facing a potential sentence of life in prison, and had not received any deals under the previous district attorney. When Chesa took over in January of 2020, within 2 months of assuming office, he cut Troy Mcallister a deal and allowed him to plead to a single count of robbery, dismissed all the other allegations, the prior convictions that were alleged that enhanced his potential sentence, as well as the other charges, and released him immediately from custody in early March 2020. He did not even wait for sentencing. Troy Mcallister was ordered to return to court a month later in April for sentencing, which he did, and was sentenced to the time he had already served in custody, and released back onto the street without any conditions other than being subject to parole. During the next 9 months, Troy Mcallister was arrested at least 4 times, never charged by Chesa's office, until the afternoon of December 31st, 2020. Troy Mcallister stole a vehicle, and while high on drugs and alcohol, drove that vehicle into the heart of downtown San Francisco at the intersection of 2nd and Mission, which, as many of you may know, is a 1 block from the Salesforce Tower. And he drove that vehicle high on drugs and alcohol at 60 to 70 miles per hour into that intersection. And he struck these 2 innocent women, 27-year-old Hanukkah Abi and 60-year-old Elizabeth Platt, who were crossing the street, and killed them. He fled the scene as they lay dying in the streets, and fortunately was arrested. When I found out about this decision that Chesa had made to release this 8-time convicted felon, now 9 times having pled to a new robbery, immediately back onto the street, I was just shocked. And having been a prosecutor for 30 years, I frankly had never seen or heard of a decision by any district attorney that was so reckless and dangerous as the one that Chesa had made, and in this case had cost the lives of these 2 innocent women. So that really kind of shook me to my core as a prosecutor, having again been prosecuting for 30 years in 4 different counties. The next event that occurred, and that was really the final straw for me, was like Brooke. I too tried a case that lasted for 7 weeks. It was an attempted murder case, and the defendant at that time had 9 prior felony convictions. 4 of them were felony assault convictions. 3 of those were against girlfriends. And in my case, he shot his girlfriend in the stomach in broad daylight on California Street near Scott, which is about 3 blocks down the street from Molly Stone's, if you're familiar with that area. And he left her to die in the street. Fortunately, an ambulance happened to be passing by within the next 2 minutes and picked her up, whisked her off to the emergency room, and she survived. So I tried that case over the course of 7 weeks. The jury did convict him. I went to prepare my sentencing recommendation, which is a standard process after any trial, any felony trial, which I've been doing for all throughout my 30-year career. And for the first time ever, I was asked to submit my sentencing brief for review, not just by a supervisor, but by the district attorney himself, by Chesa. Within an hour and a half of submitting my brief to him for his review, I received word back from an intermediary that he was instructing me to strike 10 years of time off the 30-year prison sentence that I was recommending to the judge. And the instruction that he gave me, in my opinion, was illegal. In other words, the way in which he was asking me to strike those 10 years from the sentence was not lawful. And so I explained that to the intermediary, who was the chief assistant. He agreed with me. So we had a discussion about how the 10 years could lawfully be stricken or reduced from the 30-year recommendation. Ultimately, what he came up with was such a ridiculous suggestion that I basically asked the judge to strike the 10 years based on reasons that would be provided by the defense attorney, since we couldn't come up with any legal basis to do so. And I, at that point, withdrew from the case, as Brooke incidentally withdrew from hers as well. We both withdrew as counsel of record in our respective trials. I withdrew from mine, and ultimately, on the date of sentencing, resigned from the office. What was more appalling to me, frankly, than the fact that I was being asked to do something that wasn't legally permissible by reducing the the 30-year recommendation in the way that he was asking me to do so was the moral reason that or the moral basis for him asking me to do so. Why would he want me, the people, representing the people and the victim in this case, to cut 10 years of time off a sentence for a man who has now been convicted 9 times of felonies, 5 times for felony assaults against girlfriends, in a case in which he shot his girlfriend and left her to die. So I found his intervention in my case to be so reckless and appalling, frankly, that I felt that I had no choice but to resign. And Brooke and I chose to resign together on the same date in October to join the recall campaign. And here we are. So thank you for having us. And I guess we're here to answer any questions.
Thank you for those very compelling stories. And it's just disheartening and pretty scary as from what you've also, in the times that I've seen both of you in the past and heard you speak, other things that have come up, it's just amazing. And I applaud you for taking these steps, having the stamina and the integrity to do what you have done. So with that, I'd like to open it up to questions. And President Tony, perhaps you can help with who has their hand up, or?
Yeah.
Betty, I have a question.
Ricky has his hand up.
For one or both of you, as far as I'm concerned, as I study this, the elephant in the room is how much did his father's incarceration impact his judgment in terms of assigning more lenient sentences on criminals such as you have described to us this morning?
Let me take a crack at that, and maybe Brooke has maybe wants to comment as well. As many of you may not know, Chesa's parents left him when he was a 1-year-old baby at home to go rob a Brinks truck in New York on behalf of the Weather Ground, which is a domestic terrorist organization that his mother and father belonged to. So as a result, during the course of that robbery, 2 police officers and a security guard were murdered or shot dead during the course of the robbery. So both his mother and father were convicted and sentenced to prison. His mother pled to a 22-year prison sentence. His father went to trial and was convicted and was sentenced to life in prison. His mother was released after 22 years. His father was just incidentally released by being granted, his sentence was commuted by Governor Cuomo on his last day of office in New York. But in any case, Chesa grew up realizing that his parents left him at home to go commit this robbery on behalf of their cause, the Weather Underground. I'm not a psychiatrist, but I can't help but think that any child who grows up finding out that their parents found it more important to rob a truck on behalf of their cause than to stay home and raise their child would not want to blame the parents, but would find some other way to attribute the blame, and would point to perhaps the criminal justice system as being wrong for having incarcerated them for so long. And so in any case, for whatever reason, he became a public defender, and which made sense. He was defending the rights of people who were facing incarceration, and that was his career. The fact that he chose to run for district attorney, whose primary obligation is public safety and the rights of victims, not defendants, was really, an aberration in his life story, in my view. I'll defer to Brooke. Maybe she's got some other views.
Yeah, just to add a little bit, I think he's been clear it had a profound impact. He talks quite a bit about having to go visit both of his parents in prison. It is sort of shaped his lens and the way that he views the world. And he was asked about that when he was interviewed just last week by The Standard, the new, news agency out here, about whether or not his parents, particularly his father's incarceration, has affected him. And he said, of course it's affected me. Having to grow up that way, it would affect any child. And like you can imagine, any child would want to think, wish that they had the power to help their parents get out, which is why, in my view, it makes perfect sense that he ultimately chose to become a public defender, to be the person who gets people out of prison. The other thing that it's done is, as many of you may know, his parents were the getaway drivers. They weren't actually the shooters that killed the three men. And so that has also seemed to have a profound effect on him, which he talks about also, that he doesn't view their behavior as culpable or as culpable in what happened. And so for him, he has looked at ways to find sometimes excuses or reasons for leniency. And his primary focus has always been on the people who have been incarcerated. The victims, particularly in his parents' crimes, appear to be more of an afterthought in his calculus. And so one of the ways that he looks at it, as he expressed in this interview that I just referenced, is, he was asked, what do you think a more fair punishment for your parents', involvement would have been? And he says, nothing would bring those three men back. And I've heard from a father of a little boy who was murdered in this city since Chesa took over. And he expressed that Chesa told him the very same thing, that no amount of time would bring back his son. And so in his view, a lenient sentence for one of his son's killers was justified. And so it has widely shaped the way that he does his work and views the criminal justice system.
Great.
Thank you both.
Thank you. I've got Tim Durkin put a question out in the chat. Is Chesa subject to charges of prosecutorial misconduct, or does he have or hold prosecutorial immunity?
Any district attorney has immunity in charging decisions. It has absolute immunity for that purpose. I'm trying to look at the question here. Is subject to charge of prosecutorial misconduct, well, he has immunity in the charging decisions, and frankly, I think probably the sentencing decisions as well. And any decisions he makes in his capacity as the prosecutor, he does have immunity for. With respect to prosecutorial misconduct, unless he's the attorney in court actually handling the case, it's hard to see how any judge would find that he has committed prosecutorial misconduct, or any court, such as an appellate court, would review. Ordinarily, prosecutorial misconduct would be found either by the trial judge or by a reviewing court, like an appellate court, based on the prosecutor's conduct in trial. So since he's not in trial, that's not likely to happen. There is an issue, however, where he's been accused now twice in two separate cases of essentially directing his attorneys to withhold exculpatory evidence, in one case from a search warrant and in another case from an arrest warrant. And it's an absolute clear violation of federal and state law to withhold exculpatory evidence from either a search warrant or an arrest warrant. In one of those cases, the investigator, well, the supervising investigator challenged the attorneys who were directing his subordinate to withdraw or withhold this what they considered exculpatory evidence and took it all the way up to Chesa, and arguing that it was a violation of law to do so, for his investigator to withhold that evidence or to delete that evidence from the warrant. And that investigator was subsequently fired. So that investigator is now suing Chesa for wrongful termination. In the other case, the investigator who was directed to withhold exculpatory evidence actually testified in court under oath before a judge, accusing the prosecutor in court of directing her to withhold exculpatory evidence from an arrest warrant. So whether those two cases end up getting taken to the state bar, and blame can be attributed all the way up the line to Chesa, is an open question. But it would be clearly a sanctionable violation by the state bar if that were found to be true.
Great. Thank you so much. Susan?
As you probably both know, and Dawn, I saw you on Bill Maher and you were excellent.
Oh, that was Brooke. Don't confuse
Oh,
me.
I'm sorry. I meant Brooke. Oh, yeah. Well, you can see how glitchy I am. One of the things when Chesa spoke to us that I learned that I didn't know, because he's also been accused of not filing charges against criminals, is that he can't file charges unless the case is brought to him with evidence. And very shortly thereafter, there was actually it was even on national TV, the case of a crime being committed, the police being called, and the police standing there, and they caught video of it. And I think that's called blue flu or passive aggressive, or let's see what we could do to cast a bad light. So I'm just wondering, what you said is my heart goes out to these families of victims. What you said sounds so convincing, but how do we adjust that with people accusing them of being soft on crime, but the police aren't arresting and casting that light?
Yeah, and at no point would Don or I try to justify what the police did in that situation. In my view, it's completely unacceptable. And when you talk to them, they will tell you that they are demoralized right now. They feel that, the work that they set out to do every day, that they sometimes risk their lives doing, that they often miss their families and kids events, doing, seems to be of no import or usefulness to the DA's office, because even if Chesa is charging the cases, which it tends to be his argument now, is that they're being given away right on the back end for very, very extremely lenient pleas or actually dismissals. And so the cops feel like, what's the point? At this point, why, put ourselves at risk? Why go out there and work these long hours when nothing's going to result from these arrests? In my view, that's still not the right mindset to have, regardless of what the DA's office is doing. The police should continue to do their job and do it correctly and effectively. Chesa's, telling the truth, right? He can't charge a case that the police don't bring to our office. And we would never attribute unsolved, cases, right, as sort of on his shoulders, because they're not his fault. And particularly things like auto burglary, they're very difficult to solve for the police. If they're not there watching it happen, it takes about 90 seconds for somebody to smash, grab, and run. But the issue is more so that in the cases that are being presented to the DA's office, what are they doing with them? And now one thing that we didn't point out yet is that when Chesa fired those 7 people that first day, who he replaced them with were people from the public defender's office that he used to work with. People who had been public defenders for some of them over 20 years. and they were put in management positions in our office immediately. One was made the chief of the criminal division, so the very head of our felony units. Another was made the manager, and now has been since promoted actually to chief of our charging unit. So of the division in our office that is responsible for making the decisions when the police come in and bring a case, right, and make an arrest and come and submit their case. It's a public defender who makes the decision as to whether we charge the case, and if we do, what charges we file. And so we have seen a stark contrast in what was being, even if we are charging the case, which many times we have not, but even when we are, what charges are being filed has changed, because now it's being viewed through the lens of somebody who for the past 20 years spent their time trying to get charges dismissed for defendants. And even when they make it past that point, we are seeing, as you may have seen in the Chronicle, his rate of diversion has gone up 20%. His conviction rate has gone down 20%. And that's not just in property crime cases or low-level offender cases. We're seeing this in armed carjackings, robberies, residential burglary cases. I could even tell you a murder case where a woman spent about a year in custody while her case was pending, and then we pled her out to credit for time served and put her on probation. Never mind the fact that she participated in the murder of her father, and then in an attempt to dispose of his body, they cut the body into pieces to dispose of it. And so this is extending to areas that you all would never believe, because it doesn't just stop at the auto burglaries. It goes all the way through. And so that's why, when I say not to excuse their conduct at all whatsoever, police should be doing their job to the fullest extent. But when they're devoting resources and time, hundreds of hours sometimes, to these investigations and finding out that a murderer is back out onto the street amongst us within a year's time, it gets to them. And, unfortunately, some of them have allowed it to influence the way that they behave and do their jobs incorrectly.
Thank you for responding to that. We had another question from Katie. Did most of the other 81 ADAs resign for similar reasons as yours?
Well, I'll go ahead. We can't say that all of them resigned for the same reasons. We know that Brooke and I know a lot of them personally, and we know that there was a lot of frustration among them, and a lot of them left to find jobs wherever they could. I mean, we had a manager of our homicide unit who resigned and took a lesser paying, I assume lesser paying job, because she went to a much smaller county, and in a non-managerial role. And so she left the job of being the manager of San Francisco's homicide unit to take a line position in a smaller county. And there, we had two other female managers of the felony prosecution units who left. One, again, took a line job in a smaller county. The other one left and just found a job in the private sector. So it's, we can't say, certainly not everyone left for the reasons that Brooke and I did, but an awful lot of them did.
Okay, great. I have another question for you. On the polls, what are polls saying currently about whether or not it looks like he's going to be recalled? How is that going? What do you think the polls are?
So the latest poll, I believe, was taken in, the actual polling was done in late February. And it said that out of 800 registered voters that were interviewed or that the poll was sent to, 68% supported the recall. 74% had an unfavorable opinion of Chesa Boudin. And so and didn't necessarily feel like he was doing his job to promote public safety. And so from the polling, it looks like the majority of the city right now supports this recall and does feel that Chesa's, not doing what he's supposed to do as the chief law enforcement officer of the county.
Great, thank you. Janice,
And just to be fair, I'm sorry, just to be fair, Tony, Chesa's team took a poll as well and expressed that from their data, it was around 50-50. So, either way you shake it, a lot of people support this recall.
Okay. Janice, did you have a question you wanted to ask? It was in the chat, but about Chesa's motivation for being lenient.
Yeah, you can just do me a favor and just read it from the chat, Tony.
Yeah, it's basically, do you know what do you think is Chesa's motivation for being so lenient in these heinous crimes?
My perception it has always been that Chesa has refused to embrace his role as the district attorney. And I don't know that Chesa necessarily has had the desire to embrace it. As we've talked about his past and his upbringing, and the fact that he began his career and spent the first, 8-9 years of his career as a public defender. That's the mindset that he has brought into the DA's office, which is one that is solely focused on what outcome is best for the person charged with the crime. And he has been unable to shift that way of thinking into one where public safety is your top priority. He continues to make decisions that are solely focused on what he thinks is the most fair and the best for the criminal offender. And you just can't do the job that way. And there's a reason why he is hired, or now 2/3 of our office is managed by public defenders that he brought over, that he used to work with. And it's because they share that mindset, and he wants that to be the primary mindset within the office. As we've pointed out, 61 of us have either been, 7 were fired, the rest have left. And over half of the attorneys that he's hired to replace us have come from a public defender's office. That is, or a defense background. And that's quite astounding, right? It tells you the direction and the mindset that he wants attorneys in the office to have. But that appears to be his motivation, is that he just simply only cares about, helping the criminal offender who he views actually as the victim.
Let me give you all a very concrete example of what we're talking about. When Chesa took over, there was a murder case that was being prosecuted. It was in the pretrial stages. They were litigating motions. It was a retrial of a murder case where the jury had hung 11-1 for guilt. So this defendant, but for one juror, was nearly found guilty by a jury of murder. Or in almost every circumstance, any DA would retry that case. But for one juror, they would have found him guilty. Instead, when Chesa came in, he first fired the prosecutor who was retrying the case, who had tried it previously, who was the only African-American manager in our office, and fired him. And then he resolved the case rather than allow the murder case to be retried. He resolved it and allowed the defendant to plead guilty to 2 low-level felonies and be released immediately from custody, which is shocking. When I was the district attorney in Solano County, I retried, or not personally, but I authorized the retrial of a murder case for a 4th time before we secured a conviction. And to not retry a murder case where we came one juror shy of a conviction for murder is unprecedented in my experience. So in any case, he released this defendant After allowing him to plead to 2 very low-level felonies for the time he'd already served. And that defendant went out in 6 months later and committed 4 residential burglaries with accomplices, 2 of them involving home invasion robberies where the victims were home at the time. In one case, it was an 83-year-old Asian female, and the other was a 16-year-old girl asleep in bed who was awoken by the defendant and his accomplice to burglarize the home. And even in that case, he allowed the defendant to plead to 1 charge of commercial burglary rather than residential burglary. And for the time he had served in that case, I think he did a year in custody and that was it. And he was back out the door. So this is how he treats even murder cases. And that's just one example.
Okay. Alan Garber, you had a question? You're on mute.
I'm unmuted. Brooke and Don, thank you. I want to thank both of you for what you're doing. And it takes a lot of nerve and cojones to do what you did, resigning along with these other people. And I congratulate you on your what you're doing. And actually, I just see a question from Carl Walsh, which is exactly what I was going to basically ask you is, there's a similar attempt down in Los Angeles with George Gascon, who was predecessor to Boudin, to recall Gascon down in LA for basically the same stuff that's going on up here. And I'm wondering if either of you have any insight into that, and if you have contacts with people down in LA and see if there's anything that is going on there similar to here.
Let me just say that George Gascon, as the San Francisco DA, was tough on violent crime, and he has completely changed his approach down in Los Angeles. But when Brooke and I worked for him up here, he was progressive, but he was tough on violent crime. So, you know, what he's doing down there is completely different than what he did as the San Francisco DA.
Interesting.
Yeah, a lot has changed. And I think that's somebody put in the chat that they've, you know, his statements and actions are often mirror Chesa's. That seems to be the complaint. I recently did a podcast interview with, it's called True Crime Daily, but it was with a former prosecutor in LA, now defense attorney who hosts this podcast. And he interviewed myself and a deputy district attorney in LA, who's the head of the vice president of their union. And what he was expressing was that George came in and issued a number of policies, including that he wouldn't charge enhancements at all, that there was a list of misdemeanor crimes that he would not prosecute whatsoever, and that they have seen very similar policies to what we have here in San Francisco, and that's what they're citing as the issues that they're facing.
Great questions. Eddie, you have a question?
I have a lot of questions. Yes, the first thing is the institutional knowledge that has disappeared from the office. How long, once it is turned around, will it take? That's a tough question, to get back with the skill and expertise of the assistant DAs. That's one question. And I think the bigger problem that I see is that Boudin is very articulate, manipulative, and plausible to listen to him. And that is my biggest concern, because I listened to him. He was a guest here several months ago, and he just sounds so smart and knows what he's talking about and so forth.
Very smooth.
Yes, and people need to know the facts, which is what you're doing. And I know the campaign is moving along under Lily's tutorial and Mary Jung's and so forth, but we all need to be, what do we do to compensate for that, and how do we spread the word to our friends, those of us that cannot vote in San Francisco?
So I'll tackle the second one. first, and then if Don wants to chime in, of course, do that, Don. Yes, Chesa is articulate. There's no question about that. But Chesa's rhetoric and his message rely upon people not understanding the intricacies of the criminal justice system, not understanding who the players are and what their specific roles are, not understanding what avenues are available to you as a district attorney to resolve a case or to push someone towards rehabilitation, or how you make the decision and the calculation of whether that's not going to work and they need to go to prison. Let me give you an example. One is that he has at many times deflected blame on judges. He has said judges are who are releasing these repeat offenders back out onto the street. Judges are who make sentencing determinations. It is not the DA's office. We are not the ones responsible for criminals being back out onto the street while their cases are pending, nor are we the ones who are responsible for what their sentences are at the time of that their case is resolved. And so to some people, they would say, yeah, well, that totally makes sense, right? It's the judge. They're the ones in charge. But that's actually not true. Yes, the judge makes when somebody comes in first to court after they've been arrested, that's when they are arraigned. And they hear the charges that are against them and they enter a plea. 100% of the time, that plea is not guilty. And then you proceed forward with an argument about whether or not the person should remain in custody. And the defense lawyer stands there and generally makes, a very long and passionate argument about why their client deserves to be out while the case is proceeding through court. The judge generally turns to the DA's office and the assistant district attorney sitting there in court handling that case and says, what is the DA's position? And the assistant DA who is standing there has an obligation to address the public safety concerns for that person's release. Sometimes we don't have any. If it's maybe it's whatever it is, the person has no criminal history, it's their first offense, and it's a low level offense, we might say, judge, in this particular circumstance, we consent to release. But what we are seeing is that in cases with repeat chronic offenders who have offended time and time and time again, have multiple open cases, or even violent offenders, the assistant DAs are constrained in what they're allowed to say by Chesa. They are not allowed to ask for bail whatsoever. They are not allowed to request for someone to remain in custody unless basically they've committed murder or rape, which is the only legal basis for detention without bail, where the judge can hold you under the law and not allow you to even post bail. And so the DA's office essentially is either remaining silent when the judge turns to them, or they're agreeing that the person should be released back out into the community and saying, well, maybe just put an ankle monitor on them, or maybe just make them call and check in with this agency to make sure that they're not, absconding somewhere. And so people are being released back out, and it's not the judge. The judge is saying, well, I have this long, passionate argument from the defense, and I have the district attorney's office who's not opposing it. So as the judge, well, fine. If both parties agree that the person should be out, then that's fine. On the second one, right, the second example, which is pleas, the district attorney's office offers a plea, right? We say, okay, we're going to offer you 2 years, right? Or we're going to offer you the few days you already spent in custody and probation. And then the defendant agrees to that. And then we take it to a judge. The judge says, okay, basically stamps their name to it and lets the person out. When he's telling, people these things, it relies, like I said, upon their lack of knowledge of how the system works. And so Don and I have tried for the last 5 or 6 months to just go around and talk to as many groups of citizens as we can, try to be on any sort of news medium that we can. I'm doing every interview basically that I'm offered in order to get this message out so that people understand how the system works, so that I can challenge back against these statements that he makes I'm doing another podcast interview tomorrow where we can get in depth into these types of topics, so that people can hear the truth. And while the campaign is paying for advertising, that you will begin to see, or may have already begun to see now that we're getting close to the election date, those are sort of the only avenues that we have. And I'd be happy to share with you the links to many of the interviews that Don and I have done so that you can circulate it amongst your friends. But that's sort of what we've been relying upon, is, sharing those interviews through social media, sharing them with others so that they can continue to use whatever means they have to share them, so that we can sort of straighten out these misstatements, because they do sound convincing when he says them.
Let me add to Brooke's comments. Brooke was referring to the situation where the judge has to make a decision whether to release defendants from custody while they're at arraignment when they're facing trial, and our prosecutors and the San Francisco prosecutors are hamstrung by Chesa's policy, his rigid policy of never seeking cash bail unless the crimes qualify for detention without bail, which are either violent crimes or sexual crimes, or the defendant is a proven flight risk. Those are the only three exceptions. There's also the situation where a defendant is being sentenced, and Chesa, as Brooke points out, Chesa has often deflected blame for the sentencing decisions onto the judges. By the way, I'm very much aware that we have the retired presiding justice of the First District Court of Appeal online here, Justice Hanlon, and I appreciate his kind words to us, by the way. And so he certainly is aware of how this works, although he was a federal judge. The district attorney will often offer, in most cases, offer plea bargains, which will include a sentencing deal. And so if somebody is charged with, say, 5 crimes, the district attorney will come in and say, if he pleads to one of them and agrees to spending 6 months in jail and being placed on probation, we'll dismiss the rest of the charges. The judge is in the position to approve that deal, but the judge could also not approve it. The problem is the DA under Chesa has been going in and offering these incredibly lenient plea bargains in so many cases. And the judges are in a difficult position in San Francisco because, unlike Justice Hanlon, they're elected every 4 years. I think it's for 4 years. And
Judge Hanlon was a state judge, not federal.
Oh, okay. I'm sorry. Okay. I thought he was in the federal court.
No.
In any case, they're elected every 4 years, and if the judges push back too far against what the attorneys the public defender is saying, public defender could do one of two things. They could either move to disqualify that judge from hearing criminal cases, which they've done, and they've successfully caused judges in the court to essentially be moved over to the civil courthouse and not try criminal cases anymore. Or they could, as happened a few years ago, the public defender under Jeff Adachi ran 4 of his own public defenders against 4 sitting judges. And so the judges have to be careful if they're going to push back against not just what the public defender wants for his client in the way of this lenient sentence, but what the district attorney is also consenting to and saying, yeah, we want this lenient deal. And for the judge to push back and say, I'm not going to approve this. It does happen, and judges do from time to time reject plea bargains, but they have to be careful if they get too far over their skis that they're going to either get disqualified from hearing criminal cases or possibly have somebody run against them. So when Chesa blames the judges for the sentencing decisions, it's really disingenuous. It's really the district attorney who drives many, in fact, most of these extremely lenient plea bargains and sentences.
Don, I still think it's 6 years for Superior Court judges to run.
Okay,
Right.
I was
6 years.
I wasn't sure about that. But Judge Hanlon, you also had to run then as an appellate judge?
Yes, every 12 years. believe it
Okay.
or Not. I ran once.
So you didn't,
Before he
frankly, you
retired.
didn't face the same pressures that these local Superior Court judges in San Francisco face politically.
No, I did not. We had, I started with Ferdin when I first went in the criminal division and went all the way up through until Hallinan, I guess.
Wow.
Everybody, thank you, Don and Brooke. We appreciate you being here today. Colin, do you have a quick question?